Thank you very much, Wendy, for a minute there. My mute wouldn't work. So, but yes, yeah, I am. And I'm one of those very lucky people who live in Hearties and work remotely. And I haven't seen the office for about 15 months now, I suppose. And I'm absolutely loving it because I used to spend at least an hour a day on the William Nicol. So I really thoroughly enjoyed the previous conversation. But yes, I'm going to be telling you 10 things that you should know about the Protection of Personal Information Act today. I still call it Poppy. And I was very glad that you still call it Poppy too, Wendy. I know these days they call it Popeye and Poppy and Popi and the Popi Act. But 11 years ago, when this was a bill, we all used to call it Poppy, and it will always be my Poppy. So thank you very much for this time today and for listening to me. I just want to confirm that you can see my slides.
Yes, we can see them. Please proceed.
Thank you. And they are moving. Fantastic. Thank you very much. So I'm going to tell you about Poppy's background and the timeline, to whom the Act applies. I'm going to speak about the difference between personal information and special personal information. When can personal information be processed? Very, very important. The role of the information officer, and I think there has been a bit of panic out there because of the Information Regulators Portal. We'll discuss that briefly. Transporter transfers of information. We're going to talk about prior authorization, which needs to happen very quickly if you need to do it. Security compromises, I think very important for this fraud prevention seminar today. We're going to discuss non-compliance, what happens, and if we get time, we'll go through our Poppy checklist, but I'm not so sure if we're going to get time to do that. So anyway, let's move on. So we're getting into the background as far as Poppy is concerned. Who is Poppy's mother? So the OECD privacy guidelines came out in 1980, and that was basically the genesis of these privacy principles or privacy conditions in terms of Poppy. That was followed by the EU directive, and the EU directive, you may know, was replaced by the General Data Protection Regulation, or the GDPR, almost to the day, 3 years ago in May 2018. So Poppy's mother is the EU directive, Poppy's sister is the GDPR, and Poppy's got lots of sisters throughout the world because a lot of us are based on the EU directive. And then, not surprisingly, Poppy says when we interpret the Act, we must consider international standards. But then there's always a twist in the law. So Poppy also gives effect to our constitutional right to privacy. And that makes Poppy very different to some of our sisters, or most of our sisters and brothers around the world. So Poppy started off as a bill in 2009, and then we've been waiting for a very, very long time since it became an act in 2013 for our president to announce the commencement date. So that finally happened in the midst of remote working, midst of COVID-19 last year, and the act commenced on the 1st of July. But everybody was granted a 1-year grace period before we have to comply with the act. So we're in that grace period now, and come 1 July 2021, everybody needs to be Poppy compliant. I think I checked it, we've got about 42 days to go, so the clock is really ticking. So when does Poppy apply, or to whom does Poppy apply? In terms of Poppy, we've got certain role players. And by the way, hopefully at the end of the session, we've got a little bit of time for Q&A. We've got the data subject, and the data subject is the person to whom information relates, and that can be a human being or it can be a company. Poppy includes companies, juristic persons, unlike our brothers and sisters throughout the world, except apparently for Colombia. And we do so because we're giving effect to our constitutional right to privacy, which recognizes human beings and juristic persons. Then Poppy regulates a responsible party, and a responsible party, called a data controller overseas, is that person who decides what to collect, why to collect it, what to do with that information. But that person can't do everything itself. So very often you would outsource some of your tasks that involve the processing of personal information to third parties or agents, and we call them operators in a Poppy world. It is mandatory to enter into a contract with your operators, at the very least, telling them to keep your information secure. And then we've got our regulator, headed by Advocate Pansy Takula. Their term is already coming to an end in December, and then we'll get a new regulator. But basically, anybody can run to the regulator and bust you for your wrongdoings. And I think we're going to see a lot of competitors going to bust each other or one another at the regulator. So when does Poppy apply? Poppy applies, subject to certain exclusions. In the law, there are always exclusions, to the processing of personal information that is entered into a record in South Africa. So we must have processing, we must have personal information, there must be a record, this information must be retrievable again in future, and it must be happening in South Africa. We don't care whether the data subject is in South Africa, is an illegal immigrant, is a South African citizen, or sits in the USA, sits in Rwanda, or on the moon for that matter. We care about the fact that that person's personal information is being processed in South Africa. So that brings us to the processing of personal and special personal information. So processing is anything with a verb, any activity, absolutely anything that you do with information, collecting it, storing it, even when you destroy information, it would be seen as processing. So whatever you guys do with personal information would be seen to be processing. So that brings us to what is personal information. So we've got a list of stuff that includes things like race and gender, sex, education, medical history, and so on. But the stuff on the list in the definition of personal information is only personal information if it relates back to an identifiable person. So we have to have something on the list, it's probably not even a closed list, and then we have to have that identifiable person in the background. For example, if the data is de-identified, Poppy won't apply to it. And this identifiable person I've mentioned to you already can be a human being, it can be a company. But incredibly importantly, especially for today's audience, is the fact that Poppy draws a distinction between two categories of information. We get the black types of information, and we call that ordinary personal information. And that includes pretty sensitive stuff, such as a person's criminal history, their names, their contact details. And then we get the stuff that I've highlighted in red. I call it red flag information, but Poppy's got a special name for it, and Poppy calls it special personal information. Special personal information must be treated with care. Generally, with your black types of information, including a person's criminal history, so a person has been convicted of fraud, we can use it even without the person's consent, provided we've got a lawful justification to do so. Lawful justifications would, for example, be consent, but doesn't have to be. It could also be it's necessary to pursue our legitimate interests, or it's in your legitimate interests to know about convicted criminals and fraudsters and the like. But the minute we hit the red flag information, the rules change. And then, again, as a general rule, we need consent or we need a clear-cut law telling us we can process that information. So, for example, health information can be processed in terms of the COVID regulations and so on. But specifically important is the type of red flag information called criminal behavior of a data subject if it goes to the alleged commission of an offense or proceedings in this regard. Here, the person hasn't been convicted yet. We think he or she has done something wrong. We caught them on CCTV cameras or something like that. And then proceedings in that regard, investigations, hearings, and so on. That is special personal information. And that gets a bit tricky in practice without consent. We can rely on things like we're giving effect to an obligation under law or protecting a right under law. But where we can get consents It makes our life a little bit easier. Now, with the South African Fraud Prevention Services, I understand that you host a database with members, lists, where members can list cases of confirmed fraud. So where it is confirmed fraud, there we are dealing with ordinary personal information. But if you were to list alleged fraud, that is where you would be processing special personal information, and you would need to be a little bit more careful. I've mentioned that there are instances where Popi doesn't apply, for example, data that has been anonymized or de-identified. Now, when can we process personal information? Now, one of my pet hates is when a client comes to me and says, in a paragraph or two, tell me whether the following is Popi compliant. You can never say something is fine or cool beans in terms of Popi unless you check at least 8 things. So we have to comply with 8 conditions of lawful processing. That is the heart of Popi that sits in Chapter 3. And if the information is red flag or special information, then extra conditions apply. If we were to send that information overseas, extra conditions apply. So the 8 processing conditions are briefly as follows. You must comply with Popi, and you must be able to show you comply with Popi. And that is accountability. And here, what is useful is to have a data protection policy or Popi policy. You must have a Popi compliance framework, and you must do awareness and training with your staff. Conditions 2, 3, and 4 all go hand in hand. You must have a lawful purpose for processing a person's information. So first of all, identify what is your purpose. We're going to have this database where people can check fraud and so on, but you have to have a lawful purpose. Then you must only collect as little information as you need to fulfill that purpose. And you must have a lawful justification for processing that information. The lawful justifications would include things like legitimate interest, consent. There's a law that says we must be giving effect to a contract. But the minute we read special personal information, something like legitimate interests would not be strong enough. We generally would need consent or a law or exercising or defending rights in law to justify the processing of special personal information. Then you now have a purpose, you're only collecting as little information as you need, you've got a lawful justification. Also keep that information for as long as you are authorized to keep it only. When you are not authorized to have that information, get rid of it in a secure manner. When are you authorized to have information? You're authorized if you've got consent, if there's a law that says you must, and if you've got a lawful business reason to keep that information. That's generally the ones we rely on. So a record retention policy, important here, that sets out the different statutes and statutory periods and guidance for non-regulated documents. And then the last thing here that I wanted to mention is that anything that you do with data after you collected it, anything that you do with personal information after you collected it, must be compatible with the reason why you collected it in the first place. Don't collect information for COVID-19 tracing purposes, contact tracing, and then do direct marketing with it. So make sure that what you do with the personal information after collection wouldn't surprise the data subject. It must be something that they would understand would happen. And the data sharing policy is usually used as guidance in that regard. The last 4 processing conditions, information quality, do something, take reasonable steps to make sure all your personal information is accurate, up to date, not misleading. And the personal information here would be about your customers, about employees, about vendors, any data subjects that you deal with, whether they are juristic persons or human beings. Openness, we need to tell the data subject certain things. We need to tell them who we are, what information we collect, why do we collect that information, who do we share that information with. And we even have to tell them that if they want to fight with us, they can go to the regulator. So that is generally dealt with in a privacy statement. Condition 7, again, very important for today, is that we need to implement reasonable technical and organizational measures to make sure the personal information in our possession is secure. So those reasonable measures must be technical, that's the IT stuff, firewalls, passwords, encryption, and so on. But then organizational is common sense. If you are going to let people work remotely, give them rules as far as remote working is concerned. If you are going to lock documents in a lockable cabinet, the cabinet must be lockable and the key must be given to people on a need-to-know basis, and people must actually go and file their documents and so on. And if advisable that you use a document management system for saving, and a BCC instead of a CC on an email can lead to a data breach. So very important that staff are aware of things such as CC and BCC. And lastly, we've got data subject participation. Our data subjects are given certain rights. For example, they can ask us what information do we have about them and copies of that information. That is generally dealt with in a subject access request policy and in a PIA manual where it goes to information about third parties. The information officer, I'm not going to go into too much detail here because I'm aware of time, but please be aware of the fact that every single responsible party, if you process personal information in South Africa, regardless of whether you are domiciled here or abroad, would have to have an information officer. It is by default the head of the organization, so your CEO, and the CEO can authorize somebody else to become the information officer, and they can also delegate some responsibilities to deputy information officers. And incredibly important, your information officer and your deputy information officers must be registered with a regulator. So a portal opened up, I think it was yesterday or the day before, on the information regulator's website where these registrations need to occur. Border transfers of information, very important that you are aware of the fact that you cannot send information, personal information, out of South Africa unless at least one safeguard is applicable. That could be data subject consent. It could also be I'm sending the information to a country with adequate data protection laws, but the adequacy requirement would only apply if we're sending human being information across, because no other countries except Colombia recognize jurisdiction person information. So adequacy becomes a bit difficult because Popi is so different to other laws, but you could also rely on a binding agreement where the recipient undertakes to treat the personal information as if they are under Popi. Prior authorization, incredibly important. If you do one of four things, regardless of data subject consent, you need to fill in a form and email it to the regulator and ask for prior authorization to do this. And the one that is important for today is if you process information on criminal or unlawful or objectionable conduct, very, very wide, on behalf of third parties, and you're acting as a responsible party. So you're not just an agent here, you're actually acting as a responsible party. For example, you're running your own database, then you would have to approach the regulator and apply for prior authorization. If you're supposed to apply for prior authorization and you don't, it is an offense, and I think it's punishable by up to 3 years in jail, so it's not a nice thing at all. And that information would have to stop on 1 July until you receive prior authorization or certain timelines have passed. Security compromises. Overseas, they call these data breaches. We call them security compromises. And here we've got a nuance in our law as well. Popi says, where there are reasonable grounds to believe that personal information of a data subject has been accessed or acquired by an unauthorized person, then the responsible party must tell the data subjects and the regulator, unless you don't have the contact details of the data subjects anymore. It must be a comprehensive notification, and you need to do it as soon as reasonably possible. What makes our law different to the international standards is that we've got no threshold. In terms of the GDPR, for example, you only have to report a breach if there's a likelihood that it would cause substantial harm to human beings. We don't have that threshold. So any breaches, small or large, must be reported. And we're going to have to see how the regulator is going to cope with all these breach notifications in practice. Turkey has got a similar provision, but most of the laws across the world have some sort of threshold. Non-compliance. What happens when you don't comply with the Act? Any person can run to the regulator. It doesn't have to be a person who suffered harm, so it can be a competitor, a disgruntled employee. The regulator can try and secure a settlement. If no settlement is possible, an investigation may be initiated. And if a breach is found, an enforcement or naughty notice can be issued to tell you to change your ways. And non-compliance with an enforcement notice or other offences in terms of the Act, like trying to bribe the regulator, obstructing her when she does an investigation, and so on, can lead to 10 years in a nice South African jail, or 10 million rand, or both. The data subject or the regulator on the data subject's behalf can also go to court and sue for money. And you can sue for money for patrimonial and non-patrimonial loss. So, of course, your patrimonial loss is your monetary loss. Your non-patrimonial loss is your softer American-type lawsuit damages. So that would be things like anxiety. I feel defamed. Bad employment references made me feel bad about myself, and so on. So, yes, the Act is going to have teeth. Popi checklist. These are just quickly in a nutshell. I mentioned most of them throughout the presentation, but this is what you need to have in place by 1 July. These are must-haves. They're not nice to have. You have to have an information officer who must be registered with a regulator. You must make certain disclosures to data subjects, who you are, what you do with the information, and so on. A privacy statement does that very nicely. Some people call it a privacy policy or privacy notice. You have to have a Popi compliance framework, a data protection or Popi policy. You must do personal information impact assessments. We like to call it Popi audits, and then do a gap analysis. You must have a Promotion of Access to Information Act manual, a PIA manual, which you publish on your website if you've got a website. Data subject access request policies or procedures to help you deal with data subject access requests where they want to get hold of the information. You need to do awareness initiatives such as training, enter into agreements with operators, your third parties who process personal information on your behalf. And then lastly, in one of those 4 instances, for example, when you process information on criminal behavior on behalf of third parties, you need to fill in that nice form and send it to the regulator. So in a nutshell, that is what I wanted to cover. And very sorry that I had to do it so quickly, but this is a half an hour to tell you about the entire Act. So I had to speak quickly. I think we probably have time for 1 or so questions.
Hi, Gosh, can I ask you the first one? I think we have some others, and that is when you were talking about make sure your staff know the difference between CC and BCC, and in my experience would also be reply and reply all, because these things can lead to massive breaches. Do you think companies are to some extent guilty of assuming, or bosses assuming tech savviness on behalf of the staff that they possibly don't have, and nobody specifically says you need to understand this, and just assumes that people, we've had email for a long time now, and people surely know how these things work.
Absolutely, Wendy. So what I say is, Do something as simple as where you're not working remotely, put a sign up behind bathroom doors and say to people, do you know what the difference is between the CC and BCC? Because I think we assume that people know the difference and they simply do not. There was an HIV clinic in London who was supposed to BCC their patients about their medicine, and instead they CC'd 780 patients, and 730 of those patients were directly identifiable from their email addresses. And they got an enormous fine for this one email that they sent out. So absolutely spot on.
Thank you. Do we have? Okay, another question from Banal.
Thank you. Where do we start? We're a small organization. We are dealing with potential criminal activity and trying to identify. We're currently an organization of only 3 people. If I need to go out right now and just say I have X budget for somebody just to come in to meet the 8 requirements of your checklist, where do I start? Is there individuals? Is there consultants that we can use?
Avanal, it sounds like I planted you in the audience, but absolutely come to me. And I was going to do a last slide where I was going to say that ENS has got a toolkit, but then I thought that sounds too direct marketery and I didn't mention it. But absolutely, there are many consultants in the market, but we also have an SME toolkit to assist people like you.
Thank you very much.
Pleasure.
Anything
else?
Yes, you're speaking to Marius. Just to add to that, or just to ask a question, that toolkit, where will that toolkit, when will it be available, or is it accessible at the moment?
It's already available. Our privacy team has been designing this or drafting it for the last 10 years because we knew Poppy was coming. So we've got that toolkit available. You are most welcome to email me, and my contact details are at the end of the slides, and I'll give you more information about it.
Yeah, thank you. Will do. Thank you.
Thank you very much.
I'm certainly seeing my inbox being flooded with, not flooded, but everyday email marketing and Poppy training courses. And I think, as with all other aspects of consumerism, make sure that you choose your service provider carefully. Make sure you know the credentials, the experience and background of the person offering the training, so that you don't waste your money. Do we have any more questions? No. Okay, lovely. Thank you so much, Era. That was fascinating. Wonderful input to today's session. Thank you.
Thank you very much. Goodbye.
Okay, bye.